I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. You know what time it is. We have found ourselves walking into another compilation, and that is number 216 on our list. For this compilation, we will be in 3 different judges' courtrooms. Before I give you their names, don't forget to like, comment, share, and subscribe. Thank you for all of your comments and all of the support that you guys have been given on these compilations. Don't forget, commentary will be left in, and also chapters will be added for your convenience. Now, the first judge courtroom we will be in is that of Judge Paul Wohl out of the state of Washington. Second, we will be in the courtroom of Judge Robert McBurney out of the state of Georgia. And last but not least, we will be in the courtroom of Judge Phyllis Webster out of the state of Kansas. As always, it is a pleasure bringing you guys these compilations. And now let's jump into 216.
Are you there, Mr. White?
Can you hear me, Judge? Can you hear me?
I can hear you.
Oh, good, because I'm not good at this. And these phones are something else.
White, your ticket is for expired registration and for no insurance. And you requested a contested hearing on this.
No, I didn't request a contested hearing. I got a ticket and I sent the ticket in, Your Honor.
Yep.
For the record, on the record, and let the record show that I don't understand, I don't consent, and I didn't accept. I believe it was a Bellevue $1,500 warrant on not changing title over, which is unheard of. And then I found out there was a mistake from a next to an old hearing that I had went to, changed computer over, and they ended up putting a warrant out for me. Now I got to go deal with them on that and file a lawsuit. But on this matter, Your Honor, like I said, I don't wish to consent.
Now, Mr. White, the other case in Bellevue or whatever court that warrant is out of is not here in front of this court. The only issue in this case is the ticket you got for an expired registration and for driving without insurance.
That's what he gave me. And I'm here, like I said, on special appearance, so I want to address this issue. Make a request if there's no injured party that this matter be dismissed if it's civil. And if it's criminal, then I have a few questions I need to ask before making any decisions or any kind of pleas. Being that there's not a petition for injured party and an injured party present.
You don't need to do that because the officer who wrote the ticket has actually not made a case that substantiates the allegations that you were driving without insurance or with expired registration. So the ticket is dismissed for lack of evidence.
I appreciate that, Your Honor. Thank you, sir. Bye-bye.
Finding out about your scheduling order. Okay, let's get on the record, please, Ms. Rivers. This is 24 SC 003257, State versus Ricky Pierce. Mr. Pierce is in court. He was at an earlier proceeding. He and I had a long conversation about self-representation. I've entered an order allowing him to represent himself or honoring his request to represent himself. Today, we're going to cover 3 things, Mr. Pierce. One, we need to do your arraignment because we weren't sure if you were going to have a lawyer or be your own representative. I held off on arraignment, so we got to do arraignment. 2, I'm going to, on the record, get you the paper part of your discovery, which you can take with you. And then 3, we're going to talk about scheduling so that your case catches up with Mr. Baker's. So let's start with the arraignment.
Before we can get into that, it's a lot of issues that I had that I want to address before we get started with the arraignment. It's a lot of questions that I have that I need to be answered.
Okay. So why don't you give me an example of one of the questions, and then I'm actually going to decide whether we do arraignment first or your questions first.
Well, the law state that in Hagan versus Levine state that anytime a jurisdiction is challenged, that it must be proven before the case proceeds.
Okay.
And you're
So-
trying to proceed with this case without establishing jurisdiction first. That's the law, Your Honor.
Okay. It will work better as you and I are working together on this. If you've got legal concerns, you put them into a motion. So
I
if
have
you,
filed a motion already, but on Your Honor,
so I'm gonna look and see what's in the docket.
it states that a court cannot proceed without establishing jurisdiction first, Your Honor. This
Okay.
is the law. I'm not saying nothing that's against the laws of Georgia, Your Honor, or United States.
She can't take down, if you talk about that, she's trying to take down everything you say.
Right. So pause. Just hold on, Mr. Pierce. I'm looking in the docket here, and I'm not seeing that you filed, and it just may not have made it yet, that you filed a motion challenging jurisdiction. But I'm happy to let you know right now, I'm real comfortable with the court's jurisdiction. That doesn't mean I won't.
Your Honor, it states that the proof of jurisdiction beyond a reasonable doubt is asserted. I'm the one asserting jurisdiction here, Your Honor. So that means I have to prove jurisdiction, but you got to give me the opportunity. If you don't give me the opportunity, you're violating my rights, Your Honor.
What's in your mouth?
Paper.
Oh, okay. I just want to make sure
But
everything.
yeah, the law states that the asserter establishes jurisdiction is to prove jurisdiction, Your Honor. You're not letting me do that.
Okay.
You're not.
Okay. Well, I got you. So one, we got to speak slowly, and two, now I'm better understanding. You're saying you want to prove jurisdiction?
Yeah, I'm the asserter. Can I
Okay.
just read my question? Just go through it's not that long.
Okay. You said a whole bunch, but if it's not that long, how about I listen to you?
Your Honor, it's a lot of things I'm not understanding right now. And it's a lot of questions I need you to answer. So I can better understand what is going on up until this point, Your Honor. Like, hey, I changed the court's jurisdiction on March the 4th, 2025, and I also filed a motion that's right here I have signed by the clerk saying that it's been filed in office. This is the motion right here that I have filed. I have here something, copies back and everything. And plus, the courts are still trying to proceed with my case when you guys lack subject matter jurisdiction. Plus, it states in Louisville versus Motley, if any tribunal find absent of proof of jurisdiction over a person or subject matter, the case must be dismissed.
Okay, slow down. I'm gonna let you keep reading. Just slow down so Ms. Rivers can get what you're saying.
And also, Your Honor, once jurisdiction is challenged, it is to be proven not by the courts, but by the party attempting to assert jurisdiction, which will be me. Your Honor, the burden of proof lies with the asserter.
Okay, I'm now finding, it just wasn't listed as a motion, but I do see it's in the docket right here. Something that you filed, it's entitled Pro Se.
With a prohibition.
Right, got it. So I've got that. I will rule on that. I'm going to give the state a chance to respond. But you just filed, you filed it a couple weeks ago. And so I'll get input from the state on that. And then I do owe you a ruling on that. That does not prevent us from doing the arraignment.
Yeah, it does, Your Honor, because the law states that anytime a court jurisdiction is challenged, it must be proven before the case can proceed, Your Honor.
Okay.
So I challenged the jurisdiction last month, March the 4th. So that means that you have to set a court date for me to prove that you lack subject matter jurisdiction. That means I have bring my evidence, the state bring their evidence, show jurisdiction, and I'm not a statutory entity, so therefore statutory law don't apply to me, Your Honor.
Is the writ of replevy, is that your challenge to jurisdiction, or is there another
that's
one?
to go with my writ of prohibition.
Okay. Let me see if I got
my writ of
that.
prohibition, I filed 2 motions.
Okay, let me just take a look here.
I have a lot of questions that I need to be asked.
As long as you read slowly, we'll get through that. Okay, I think I've got your writ of prohibition also. And is that the challenge to jurisdiction?
Is that for fraudulent practices, misrepresentation, and lack of subject matter jurisdiction? Yes.
Okay, I see that. It says for fraud. Yep, they're all there. All right, so you filed them. I'm making a list here of things that I need to work on, and then I'll need to let the state respond. The way it works, if you file a motion, the state gets a chance to respond. Once I have both sides, then I can rule on that. Okay?
I mean, but you're still trying to proceed with the case, Your Honor, when we haven't established, you trying to get me to plead when this case is supposed to be at a standstill when I changed the jurisdiction March the 4th of last month. So that means you have to prove jurisdiction before I even make a plea on this, Your Honor.
I'm fine delaying the arraignment while we work through this. We don't have to do the arraignment today. I can hold on to the discovery and get you that another time. If you would prefer that I let the state respond and then I rule on it, we can handle it that way. Is that what you'd like?
I would like if we can just answer these questions that's had right in front of me today, Your Honor.
So then don't read the motion anymore and tell me what are your questions.
I wasn't reading the motion. I was reading what I have wrote down, my issues I have.
Okay, but ask questions instead of telling me about these cases.
Your Honor, I am on, let the record reflect that this is the defendant, this birth certificate, which is the person / persona, which is a legal fiction, also a statutory entity.
And I can understand.
Okay, I need you to slow down a little bit. So,
let the record reflect, Your Honor, that this birth certificate is the defendant. I'm physically showing the birth certificate, everyone in the courtroom, that this is the defendant and I am the defense.
Okay.
Your Honor, I am only here in this courtroom by special appearance on the threat and duress to administer affairs of the All Cap Trust, which is this birth certificate.
Okay.
As a sole beneficiary.
Stop. You told me you had questions. Tell me.
Yeah, I'm getting to it. I'm just introducing to the question, Your Honor.
I want you to go straight to the question now.
Your Honor, is this courtroom a court of records?
Okay. What's your next question?
Is this, you can answer it? Is this courtroom
I want to know what your questions are.
I'm asking the question, Your Honor, is this courtroom a court of records?
So I thought you were going to share with me what the questions were. I didn't tell you if I was going to answer the questions. You said you had a bunch of questions.
So you're going to have me ask questions that you're not going to answer, Your Honor? That's not fair.
Well, don't ask the questions then. You don't have to ask the questions. You said you wanted to ask your questions, and I'm happy to hear them. If it's appropriate for me to answer them, I will.
So you don't think me asking is this court of records appropriate?
I didn't say it was appropriate or inappropriate. I just needed to know what your questions were. And if they're ones that I should answer right now, like what time is it? I can tell you, 3:51.
Yeah, and I'm asking something very simple, Your Honor. Is this courtroom a court of records?
All right, and what's your next question?
Your Honor, is your courtroom a court of records? I can't get
That
past
seems like the
these
first
questions.
question.
Need to be answered before, Your Honor. This question need to be answered for me to proceed, Your Honor.
Okay, tell me
I'm
what
trying to get an understanding. If you're not trying to help me get an understanding,
tell me what you mean by a court of records.
is this a court of records? It's simple.
I don't know what that means.
Is this courtroom a court of records?
I don't know what court of records means.
Do they record and proceed on everything that's happening in this courtroom? Do they record and document everything that's happening in this courtroom?
I don't know about everything, but as long as you're speaking slowly and clearly, then things are being taken down. What's your next question?
Is this Fulton County courtroom a court of records? The same question you're not answering, Your Honor. You're trying to dodge the question.
No, I'm not. I want to make sure I understand the question.
Is this Fulton County courtroom a court of records?
At times it is.
And are you sure this courtroom is a court of records?
If court of records means we take down what is said in court, then yes, sometimes this is a court of records.
For the record, Your Honor, I go by Ricky DeMond Pierce, all lowercase letters, nothing more, nothing less. Again, I'm here by special appearance on the threat and duress to again administer affairs of the All Cash Trust as the sole beneficiary and a shareholder of the trust, which again is this birth certificate. Okay, I'm also the executive of this estate, and I'm not the living person, not the person or persona, which is a statutory entity. I'm not the all caps legal official on my corporation. I'm the living man, and I have proof signed by your government agreeing to the same.
So what's your next question?
Your Honor, before we could proceed with this matter, I have a few questions I need for you to answer. First, Your Honor, are you practicing color law behind the bench?
I'm not sure what you mean.
Are you practicing color law behind the bench? Because Title 18 U.S.C. Section 242 clearly states that you are committing a felony if you are doing so. Title 18 states, whoever on the color of any law, statute, ordinance, regulation, or custom willfully subject any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured by and protected by the constitutional laws of the United States shall be found under this title or in prison not more than 1 year or both. And if bodily injury results from acts committed in violation of this section, or if such acts include the use, attempted use, or threat of use of a dangerous weapon, explosive, or fire, shall be found under this title or in prison no more than 10 years or both. And if death results from the acts committed in violation of this section, and if such acts include kidnapping, attempted to kill, shall be found under this title or in prison for a term of years or for life or both, or may be sentenced to death. Now my question, let the record reflect that no legal or lawful matter can proceed without jurisdiction, Your Honor. We both know this.
Right. So we're going in circles. We're back.
Let me finish. Your Honor, my question to you is Your Honor, for the record, is this matter a criminal matter or a civil matter?
What do you think?
I just want to answer.
You're standing there in handcuffs. You're wearing a jail outfit.
Honor, can you please answer the question for me, please?
That's my answer. I'm answering with a question. What do you think? Lowercase
I don't know.
r,
I don't know,
lowercase
Your
p.
Honor. That's why I'm asking. I don't know.
think you
That's
do
why
know.
I'm asking.
What's your next question? Ask me
Your
a question.
Honor, Your Honor, for the record, is this matter a criminal matter or a civil matter?
Ask a question you don't know the answer to.
I don't know that. I'm telling you, how you gonna tell me what I know, Your Honor?
Well, if it were a civil matter, would you be having to use the restroom in front of everyone else?
Oh no, that's why I'm asking you, Your Honor. I'm coming to you as fast as I know how, Your Honor, and humble as I know how. I don't know. That's why I'm asking the question.
Okay. What's your next question?
Your Honor, for the record, is this matter a criminal matter or a civil matter?
Okay, that would be your next question. That's one you already asked.
Why we can't pass this question, Your Honor, because I lack knowledge to understand what is going on. And I'm telling you this, and it's my authority to let the court know when I don't understand something.
A fair point. I want you to let me know when you don't understand. We already covered that when we had our Feretta hearing. We talked about what kind of case it is and the penalties you face.
I said, is this a criminal matter or a civil matter?
How much more time do you need? Because you got about 3 minutes before I'm going to bring someone out here that we can move the case along.
Your Honor, I just want you to answer my questions because I lack knowledge to understand what's going on. I'm just trying to keep caught up to date to understand what is going on.
Okay.
There's no harm in that, Your Honor.
What's your next question?
It's the same question. Before I can get to the next question, I have to answer this question.
Go to the next question. You just said you're not going to answer.
Your Honor, for the record, is this matter a criminal matter or a civil matter, Your Honor?
All right, we're done. I will bring you back once the state has responded to your motions, and I will likely be entering an order that lets you know my thoughts about jurisdiction. Once I've done that, you can choose to participate in an arraignment, but you do need to understand that in a criminal case, that's a clue.
So this is all a criminal matter. Why you couldn't answer the first time, Your Honor?
Why are you asking in the first
Because
time?
I'm trying to get. I just told you I'm trying to get an understanding.
So let me finish. So you understand that in a criminal case,
So this is a criminal matter, for the record.
such as yours, if you choose not to participate,
Your Honor.
if you choose not to
Is this a
participate,
criminal matter or a civil matter, Your
you
Honor?
need to stop interrupting, okay?
I'm trying to understand something. It's my right to, if I don't understand something, to bring it to your attention, Your Honor. That's the law.
Well, it's not the law, it's how you're choosing to proceed. If you decide not to participate in arraignment, I'm authorized by law to enter a plea of not guilty. And that's what I'll do. So when I see you again, we're going to try again with
So
the
you're
arraignment.
going to violate the laws to when it states that a case cannot proceed without establishing jurisdiction first. So you're just going to ignore that.
Nope, I'm going to rule on your motion. And after I've done that, then I'll bring you back for arraignment. And you can choose to participate in it or not. I'm just letting you know in advance so you're not disappointed.
I'm not going to participate in it until you establish jurisdiction on me first. That's the first thing first. We're not going to skip the process. This due process of law for a reason, Your Honor.
It is, and that's why we're not
And
going
in Hagen versus Levine, it states that any time a jurisdiction is challenged, is to be proven before the case can proceed. That is the law. That is not nothing that I made up, Your Honor.
Okay. You may be misapplying it, but I'm not disagreeing.
I done read it 1,000 times, Your Honor.
Okay, well then you know it. So that's why we're not doing the arraignment today. I'll take care of establishing jurisdiction. And once I've done that, I'm comfortable that I've established jurisdiction, we'll bring you back for an arraignment. You can participate or not, but we'll have cleared that hurdle that you.
If you haven't, I'm not going to participate. If you can't establish jurisdiction over my case first, why would I participate?
You don't need to participate. I'll bring you out. You can say no, thank you. We take you back there. We bring the jury in.
I mean, Your Honor, I have issues, and it's.
You do.
Yeah.
You do.
Yeah, and we both do, Your Honor.
And my responses, do I address them to, as Mr. Pierce has recognized to start the day as lowercase r, P, the rest of his name, because he signs all of his motions with uppercase R, uppercase P, uppercase.
No, I don't. I do uppercase or lowercase everything else. Dash. I don't have an sentence. I have an autograph.
It's just different. Out of respect, I just was curious since it's different than what he.
Let me show you.
I got it right here.
Right, no, I'm looking at it. It's capital R, capital P.
No.
Oh, yes. But that's all right.
Is that all caps?
No, it's not all caps, but you capitalize each word.
This is all caps. Is this your handwriting?
What?
See, that's all caps.
Oh, that's awkward. All right.
Is that in all caps?
So how about this, Mr. Pierce? I'm going to agree that you have written it in different ways, and I'm really not going to get hung up on that.
I'm not all, like I got the paperwork right here signed by the government saying I'm not a part of y'all, and it's on file with the office. It's filed in office. My paper right here shows that I'm not the all caps legal official signed by y'all government.
Good.
Signed by y'all government saying I'm not the all caps.
I will not use all caps. I will not use all caps.
Signed by you guys government.
You guys, okay.
Because I'm a national, not a citizen. Y'all are citizens. I'm not.
I remember you establishing that before. We don't need to cover that again.
It was very much that I present it at every court because it's for the record. It's my job to put it on the record, Your Honor.
Okay, it's back on the record. We're incorporating in this hearing what you put on the record at the last hearing, and we'll do that every time. Anything else you want to cover? Because I'm happy to give you this discovery, but you can't have it.
I don't want to proceed until I get my question answered, Your Honor.
All right. Why don't you do this? If you want to put them in writing, you could file them and I can get you those answers. But we're wasting not your time or mine, an important conversation, but there are a lot of other people here who are stuck while you ask questions like, is this a criminal matter or a civil matter? So
because I don't understand.
Okay.
And I just want to ask you where is the problem just answering the question, Your Honor? Because I let the knowledge know.
Okay. I feel your lack of knowledge, and I'll bring you back after I've responded to the motions you filed. That's the way we're going to interact here. If there's something you want an answer for or ruling on, you need to file it. And you know how to do it. You did it well. Okay? I'll keep your discovery warm and dry in my office.
So would you just continue this court date or something?
Yeah, we can't do the arraignment today. You've helped me understand why. You want me to establish.
Because you can't proceed with my case until you establish jurisdiction over my case, Your Honor.
That's right.
That's the law.
It is the law.
So what's the problem with me asking the question to better understand what's going on?
Well, I don't even have jurisdiction yet. Let me establish that, then I'll be in a position to have a conversation with you.
And we're not talking about statutory jurisdiction. We're talking about the Constitution jurisdiction.
We're talking about whatever jurisdiction I find. Okay? I'll see you soon.
Bye, Judge.
That went differently than I expected. Really? I thought just by letting him vent that first time, he's sort of like he purged himself. Clearly not.
Well, guys, we come to the end of this proceeding. And as we can see, it didn't really go as planned. This was actually supposed to be his arraignment, but because of his arguments and questions for Judge McBurney, we see Judge McBurney says, listen, we're going to go ahead and postpone this thing. But he does give him a warning. Like, listen, if you don't cooperate next time, you don't follow the rules next time, you're not prepared next time, we're just going to go ahead and go forward with the case. I'm just going to have to put in a not guilty plea for you. And, we'll just handle it that way. But if you watch the first proceeding, he had the Ferretta hearing. He allowed him to go through that super long motion. And as you can hear at the end of this, when they all were laughing about this, he said, listen, I thought by allowing him to go through those motions, he would purge himself and come here on this proceeding and, be more prepared to just go forward instead of keep saying the same arguments over and over again. But we know when it comes to sovereign citizens, that's the whole point, is to keep repeating the same thing over and over again. And he came with the whole jurisdiction thing. Is this criminal or civil? Obviously, a man has been shot over a dog and killed. So we know that it's a criminal case. He's not a child. He knows it's a criminal case, but a lot of times this is just to prolong the case. But with that being said, we will continue to follow this when the next proceeding comes out, or should I say is aired. We will definitely be there to make sure we have it for you guys, because I'm interested in seeing how this all plays out. But looking at it so far, especially if he did do what they're alleging that he did, this isn't going to work for him well, trying to represent himself. But with that being said, guys, as always, I appreciate you guys for joining me here on Sovereign Citizens Hall of Fame. Thank you once again for all of your support. With that being said, guys, this is Sovereign Citizens Court. And for now, Sovereign Citizens Court is adjourned. Thank you, guys. God bless.
And Judge, I am on standby on Mr. DeBus. Although I'm not attorney of record, I will be standing by though.
All right, and that's what I'm going to call now, because it looks like it's between Mr. DeBus and Mr. Cochran. Well, I can't call, yeah. Mr. DeBus, you want to start your video? Okay, we are back on the record in 2023 TR 2777, State of Kansas versus Anthony Edward DeBus, with Jared Regier for the state, Mr. DeBus in person, and with standby counsel Darren Patterson. Standby because my prior contacts with Mr. DeBus led me to believe that he, even though he wants to represent himself, there's much about the legal system that he doesn't know or understand, and would need the benefit, or would certainly benefit, period, from Mr. Patterson's representation. So, Mr. DeBus, at this time, you want to talk to Mr. Patterson and take advantage of his knowledge and experience in the legal system concerning this no driver's license charge, registration, and insurance violations?
Let me ask first, are we on the record? Is there a court reporter present?
Is there a court reporter present? This hearing is live. It is being recorded. Is someone sitting here with their little fingers clicking across the keyboard? No.
So you're saying that this is not currently a court of record?
This is a court of record because this is being recorded, subject to transcription at any time.
Okay. I would ask for a copy of that transcription.
Well, when you file a written motion and pay the transcription fee, sir, that will be arranged.
Okay. And Phyllis K. Webster, will you please recite your oath of office into the court of record then today?
No, sir, I will not.
Why are you refusing to do so?
Let's move along.
I would please like to have that question answered. On another note, I am appearing specially, not generally, under threat of duress and further coercion by the State of Kansas Corporation.
All right, sir. I did take my oath when I was appointed and when I was elected subsequently. Now, what is it I can help you with today? Do you want a trial, a jury trial, or do you want to enter a plea today?
It seemed like last time we had court, you entered the plea for me.
I did, because you would not.
Okay.
But yet what you were saying suggested you wanted a trial, so I entered the not guilty plea and set it for trial. Somewhere along the line, you led me to believe you wanted a jury trial as opposed to a bench trial. Had I been making the decision, I probably would have said bench trial. But somewhere along the line, you've made comments to make me think you wanted a jury trial. Now, I have not seen, let me double check. I don't think, Mr. DeBoos, that you have filed any kind of demand or request or notice for jury trial. Have you?
I thought that was entered into the last court session.
Well, I don't think you filed any motion. You told me apparently you told me you wanted a jury trial, but you never followed through.
I thought that was a decision that we made as the court.
Well, you and I did not make a decision of any kind. Mr. Patterson, do you believe it's acceptable for him to just say he wants a jury trial?
Your Honor, pursuant to case law, because there are at least up to 1 year in the county jail possible, if it's ever consecutive, then case law would state that he has a right to a jury trial.
Agreed, but does he not need to put something in writing to that effect that he wants one? That was my question.
Because there's an absolute right to jury trial, he would not have to put it in writing. It would have to be specifically waived by him, Your Honor, and I don't think he's done a waiver.
Very well. Do you agree with that, Mr. Regier?
Your Honor, what I can say at this time is pursuant to KSA 6238 subsection B, quote, on any issue or trial by right by a jury, a party may demand a jury trial by serving the other parties with a written demand, which may be included in a pleading no later than 14 days after the last pleading directed to the issue is served, and found the demand in accordance with KSA 6205 and amendments thereto.
Mr. Patterson, in spite of that statutory language, do you think he needs to waive his right to jury trial? Did I hear that right?
Absolutely, Judge. Pursuant to case law, and I don't dispute the statute whatsoever, but there is certain case law that makes it a constitutional right to a jury trial if the sentence would be up to a year in the county jail, and in this case, consecutively, it could be up to a year, the longest possible maximum. So it would have to be waived by him, and he would not have to make anything in writing to receive that.
But you don't believe that case law overrules the statutory law, or do you?
This is a constitutional right we're talking about, Your Honor. It would trump the statute.
Okay. So, Mr. Patterson, when you say up to a year in the county jail, are you thinking if they were to be run concurrently, or I mean consecutively versus concurrently?
That would be the longest possible sentence when you start running them consecutively, and that's what the case law would state.
Do you have your statutory site or your case law sites by chance? I know you didn't expect to pull them out.
It's not one I keep handy, but giving a short recess, I can find that.
Well, now before you go to that, now, Mr. DeBoos, do you have any idea what's going on here?
I, as a common man, do not comprehend the legalese that you guys are using together. I can look up statutes and case law myself, and considering that this is dealing with a common right to all people under granted to us in restriction of government entities for the people itself. I comprehend that I have my right to jury trial, which I think Mr. Patterson, in his brief support towards this and towards me, towards my right to a jury trial, although I do not fully comprehend the legalese that is going on within the association between Jared Regier and yourself, Phyllis K. Webster.
All right, well, Mr. DeBoos, the point is you do have the right to represent yourself, and you've told me you want to represent yourself, and I've asked Mr. Patterson to stand by, and you've already used him here for this purpose. So here's the thing, Mr. DeBoos. No, let me talk now, Mr. DeBoos. Here's the thing. If you're going to represent yourself, you need to be able to make your own arguments. You need to be able to cite your own law. And if you cannot do that, you have the right to legal assistance, which is why Mr. Patterson is here. And you've already this quickly run into a legal snag that he's made the argument for you. Does it not make sense to you? And do you not want to have his legal assistance to let him represent you?
I do not wish to be represented by an attorney whose duty first is to the courts and not to their clients. And if we're speaking on rights in regards to laws and statutes, the arrest made on me by Deputy K. Barriquet was an unlawful arrest for
we're not going on
22-2401.
We're not going down that path right now, sir. Well, the issue is, so you do want a jury trial. Are you ready to proceed on Wednesday, Mr. DeBoos?
May I ask that there be an extension so that way I may fully research the procedures of the administrative criminal law which you're trying to try me under?
Well, I'm not the administrative law judge. That is yet another procedure.
Although you are in an administrative court under the state of Kansas Corporation, correct?
I'm here in a criminal traffic trial, and I am not an administrative law judge. So here's what we're going to do. How much time do you want this continued for?
30 days or so seems to be a standard.
Well, my next available jury trial date would be October 2nd and 3rd. So
2024.
2024. So that's when I will continue this at your request to. I'll grant your continuance, but that's my next available date. And your pretrial will be September 30th. 2024. Do you have any objections to that?
No objections.
Mr. Patterson, do you have any legal authority that suggests that I reaffirm my oath for him? Do you have anything that says I should do that?
Judge, I'm afraid I've never researched that issue, never heard that issue.
All right. Well, same here. I do have my oath in front of me. Keep it handy, but I don't see the need to repeat that. It was good enough for the Supreme Court of Kansas.
I'm not threatening you. Say one more word and that's 30 days. 30 days.